on the 27th of September, so what, 3 days ago, we got a Dropbox link with additional crime scene photos from a 2019 case, a 2014 case, and a 2015 case. These hadn't previously been provided.
Of what?
Well, I think you'd have to ask maybe Mr. Atkins or the state. One of them relates to, I just have APD case numbers. I think they could give you more detail.
Okay.
My main point being these should have been provided in December of 22 at the latest. So I don't know why we're just receiving these now. And it seems to be my role in the case. I'm here to once again complain about late discovery, Your Honor.
Not Weinstein thinking that's his role to only complain about late discovery. You offer way more than that, Weinstein.
Ms. Love?
Your Honor, I'd ask the court, since that is not something that will be broached this week at all, that the court allow us to address the matter when I have those files in front of me that Mr. Weinstein
How
is
about you get
referring
those
to.
files at lunch? Seems to me like
We
we're
can
going to
do
have a
that.
lot to talk about over lunch.
What y'all got to talk about at lunch? Did I miss something?
I will look back and make sure that they were not previously provided, but to the extent that they were not, the crime scene information that we have turned over is a direct result of matters and witnesses that we have added back.
These are cases from, according to what Mr. Atkins sent, 2019, 2014, and 2015, Your Honor. And Mr. Atkins, in an email to me on that same date, the 27th, indicated to me that these had not previously been provided to us. So we can discuss it at lunch as the court wishes, Your Honor.
So Atkins was not part of the plan to lie, and he done said that those documents were not previously provided, which means they probably were previously not provided. Otherwise, he would remember. So it sounds like you lying, love.
Did you obtain phone records for anyone related to Kenneth Copeland in order to assist in your investigation? Any information regarding either a Deshaun Quarterman or a Rontrez Brock?
Probably. I probably subpoenaed subscriber. I definitely know those names. And I definitely remember identifying their phone numbers. Okay. And if there's records in the file, then that means I sent a subpoena. I don't believe I got search warrants for those numbers. I don't think I had probable cause, but I was at least able to obtain, subscriber information and call detail reports.
Why are we still bringing up Woody? Why? I mean, like, we going into depth. Why?
Now, did you, and who?
He had been interviewed several times by that point. Several.
At the time that you got the file, had Kenneth Copeland already been interviewed?
He had been.
All right. And when you reviewed that, those interviews of Kenneth Copeland, did you endeavor to speak with him anymore, or did you gain more information from the interviews themselves that assisted you in your investigation?
Well, as the investigation, as the months went by, I did desire to speak with Kenneth Copeland.
But Kenneth Copeland had no desire to speak to you, which is why he didn't speak to you.
But that did not happen. He wasn't willing to speak with me.
And who was it that you were looking at in this interview? What was the name of the person, if you recall?
No, that I don't recall.
Okay. Was this person in any way able to give you information that led you to find Mr. Davis?
I never talked to this person.
When you interview somebody, you should know what the answer is going to be. And I didn't interview this person is not the appropriate answer to the question in front of the jury.
The information that you saw on the television instructive in determining Mr. Davis as a person of interest?
I don't know. I don't think so. That's not how I identified who Mr. Davis was. The news footage isn't how I identified him.
How did you?
So why are you mentioning the news information to us, love? It's no reference to his actual process of identifying people.
Go about finding Mr. Davis?
Well, I knew enough about them that I could reference his public records, and I don't really recall exactly how I did it. I just remember that I knew enough about this person's life that I was able to look at public records and eventually figure out get the name of Sammy Davis and the date of birth. And then I was able to find him and interview him, and he confirmed.
Hold on, don't say what he said. You were able to interview him?
Yes.
All right.
So he went off of prior knowledge to be able to find someone, and you mentioned news information. Because I'm confused. Why are we mentioning information that offers no value to the actual point of the plot line?
Did you further look into anyone that you saw getting into or out of that Pontiac?
Well, yes.
Okay. Who would you tell the jury about one person that you saw getting into and out of that Pontiac that
I'm
you
going to
looked
object.
further into?
Same question.
Ask the question again.
Would you tell the jury about one such person that you saw?
Sustained. Okay.
Did you see Diamante Kendrick getting out of the Pontiac?
I did.
Objection.
Sustained.
She tried it. It was the same question. And then you tried to get an attitude and mention the person's name that you wanted him to mention. That should have been leading as well.
Move to strike, Your Honor.
It'll be stricken.
Who did you see getting out of the Pontiac?
I'm going to object. It's the same question.
Sustained.
Your Honor,
Yes.
would the court allow me to either approach and explain or allow the state to get information we believe will be made valuable to the jury at a later
I'm
time?
gonna
In other
object.
words,
Yes,
would the
you can
court
object.
please conditionally allow us? After you saw that 2001 Pontiac Bonneville at the gas pump, did you see, can you tell the jury who it was you believed that you saw getting into and out of the vehicle based on the information you had at the time?
Well, there were multiple occupants of the vehicle, but I believe you're referring to Diamante Kendrick.
Okay.
Judge did overrule the objection, but this clearly proves the leading point that I just mentioned. If his statement to you is, well, I know that you want me to say this person, that's leading.
And what did you do once you saw Diamante Kendrick? Did you just see him or look at or observe him getting out of the vehicle, or did you do something else with that information?
Well, I wanted to speak with the other people that were with him in that Pontiac Bonneville and another vehicle that appeared in the frame at some point.
Okay.
And these interviews took place in 2015, and you were not able to determine who was responsible for the unaliving of Donovan Thomas, but we're using the same evidence 10 years later. And you still have no proof because we know it was somebody else.
Were you ever able to make a decision about who you believed the people were that were with him in the Bonneville?
I eventually determined who they were, and I spoke with them.
Okay.
When you came into this case in 2016, the case had already been with the detectives Gaither, Dennis, and Thorpe, right?
That's correct. Those were the detectives that primarily were the ones that I knew of that had been working on it, yes.
Work had already been done on the case as far as you knew.
Yes.
In fact, people had already been arrested in this case.
Yes.
And I'm talking specifically about Donovan Thomas's murder.
That's right.
All right. Because that's what you were looking at.
That's right.
And so you knew by the time that you came into this that there were 4 people who were sitting in the Fulton County Jail. Shannon Stillwell? Who else?
Antonio Sledge and Demiki Garlington.
All right.
4 people sitting in jail off of a crime that no evidence was produced for. Really?
Had already been investigated by the detectives, true?
That's true.
And so you came into this with people arrested, believing that the work had been done properly to have these 4 folks in the Fulton County Jail, right?
Well, that was my hope.
Right, right. That turned out not to be the case, right?
Correct.
In fact, tell me if this is right. I think you testified to this, that there was the interview of this gentleman named Spencer Wright in, what was it, October the 19th of 2015?
That sounds right, yes.
All right. And that
2015. Did you say 2015?
2015.
Yes, yes.
Okay. And that interview was done by Detective Thorpe, correct?
Correct.
And the next day, the 20th, is when Detective Thorpe went in front of a judge and got an arrest warrant for the 4 people whose names we've just mentioned.
So he got names, went to a judge the next day, and the judge approved it, apparently, because they was arrested with no evidence besides someone's testimony who was not there, and y'all didn't even look at the video footage.
Yes, yes, that's correct.
Right. And those 4 people were arrested and put in jail as a result of the investigative work that had been done by those detectives whose names we've just referenced.
Well, when you say those detectives, I would not, Detectives Gaither and Dennis, I wouldn't group them into that. It was Detective Thorpe that was the affiant on the arrest warrants for the Mr. Sledge, Mr. Garlington, Mr. Copeland, and Mr. Jackson, a.k.a. Mr. Stillwell.
Right. So one person swore out the warrant. That was Detective Thorpe, right?
That's correct.
Detective Thorpe, they throwing you under the bus.
You said that this was almost entirely based on the statement of Mr. Spencer Wright.
Yes.
Right?
Yes.
Okay. And it turned out that Detective Thorpe, or whoever else was involved, did a ridiculously poor job of vetting or looking into Spencer Wright's statement. Isn't that true?
Well, there were some.
Why are we stuttering? That was a yes or no question, and the answer was yes. They did a terrible job. That was real simple. Why was it complicated?
Surveillance video that Wright said he was a specific place, and there was video that would have showed whether or not he was there. That apparently was not inspected very closely prior to obtaining arrest warrants.
Right. Well, in terms of not investigated fully, Spencer Wright, Thorpe spoke to Spencer Wright on the 19th of October, right?
Yes.
Now, when you came into the case, one of the first things that you thought to do was to really examine the statement from Mr. Wright. Is that true?
Yes.
And you did so?
I did.
And you spoke to him?
I did.
One of the second or third things that you did, right, just using some common sense, was to go and look for video around the location where you thought Spencer Wright would have been, right?
That's right.
And you did that.
I did.
And you were able to find it.
I was.
And it was pretty easy.
It was.
Testifying that it was easy is actually part of the problem. That should have been done when they got the case, before it even got to you. The simple process of viewing the information of where this gentleman said he was should have been done. And there should have been reprimands that they did not do so, because it was a simple process.
Detective Thorpe, before arresting folks based on your words, almost entirely the statement of Spencer Wright, never took the time to even go look for video where Spencer Wright supposedly would have been. Did he?
Well, that I don't know. You would have to ask Detective Thorpe that.
Well, did you? Did you ask Detective Thorpe that?
Oh, I'm sure I did.
Let me guess. The answer was that he had not done it, right?
They had the video footage before they arrested 4 people and did not review it. And you responding to these questions as if it's no big deal is very alarming to me, that nothing was done in the midst of. And it doesn't seem like there's any remorse, any regret, nothing about the fact that they didn't do their job and 4 people sat in jail off of information just off of one person that could have been verified and was not verified until you got involved. The nonchalant attitude about that is not okay.
Remember the answer he gave at the preliminary hearing about the video.
Okay. Well, let me ask you this. When you come into the case in 2016, was there any video that had been procured from that location? By Detective Thorpe? Where the bus stop, where Spencer Wright would have been?
Yes.
Was there?
Yes, there was a video camera, And in the viewable area of that camera was the bus stop where Mr. Wright said that he was standing at the time of the homicide.
Right. Had anyone gotten that video?
Yes.
Who did?
It was yeah, the specific investigator was probably either Frederick Page or Teague, Jason Teague, but
Okay.
ultimately it wound up in the possession of Detective Thorpe.
Okay. Before these 4 individuals were arrested or after?
Before.
Okay. And so even having the videotape that you looked at
Mm-hmm.
and that you made a determination was pivotal in the arrest or in the case, even having that information, Detective Thorpe still went ahead and swore out the warrant for the wrong people on October the 20th?
That's right.
You weren't asked, so I'm going to ask you, whether you saw Jeffrey Williams on that video at the Texaco at around the time that the murder occurred. Did
Okay.
you?
No, I didn't see Jeffrey Williams on there, no.
And you looked at the entirety of the video, right?
I did.
Right, he was not there. That's why you didn't see him anywhere on any video footage whatsoever. He was not there.
Heard you say that on all, I don't know if you said all of them, a lot of the videos, you went back and you looked at them multiple times, right?
Mm-hmm.
So January 10th, 2015, somewhere between, let's say, 6-something and 6:50 and 7:30, the time that you looked at the Texaco, Jeffrey Williams is not on any video getting out of any car, getting into any car at the Texaco down the street from the front barbershop. True?
That's true.
Adams is cooking today. He done made this man a defense witness. He is absolutely using everything he can pull out of him today. Absolutely loving it.
Tell me, if you can, who had possession of that vehicle on January the 8th of 2010?
2015?
2010? 2015, yes.
Yes. I don't know.
You don't know who had possession of that vehicle on January the 9th of 2015?
I do not know.
And you certainly don't know who had possession of the vehicle, no personal knowledge of who had possession of that vehicle on January the 10th, 2015.
If we're talking about actual possession, like the
Actual
person,
possession.
then no, I do not know.
Okay.
This vehicle being such a vital part of the case for Donovan Thomas's situation, there should be more information and there should be firm answers. And this I don't know stuff on something that you are so adamant about is just unacceptable to me.
And I'd also object to any hearsay that may be contained within that document.
Is that an issue I need to take up?
I mean, I can show the court in.
Okay.
Well, there was a phone number posted it was a public post, and there was a phone number that was, there's a comment section to the right of the photograph, and there was a phone number posted by the account holder that appeared to be their own.
Was the account holder Justin Cobb?
Yes.
What was the significance?
I'm going to object to that as hearsay and ask it to be stricken.
Which part?
Her acting clueless. Which part? You know which part.
Part about who the number belongs to.
Sustained.
Okay. What was it that made the number in this post significant to you?
Well, I was looking for a number for Justin Cobb.
And what led you to believe that this number was a correct number for Justin Cobb?
Well, it was, there's probably more to it than just this, but it was posted in this Instagram comment, and
Was it posted by the owner or user of the account?
That was false speculation. I'd object.
Not supposed to be testifying that the information is factual because he does not have factual proof that it is. So she's already getting very close to the line.
Yeah.
If he has a basis to testify.
Are you able to see and tell, looking at the posting itself, what name the number is next to? What
I would
handle
renew
the
my
number
objection,
is
also
next?
object on the basis of hearsay if he's reading from a document.
It's already in evidence, Your Honor. And,
Okay,
And Your Honor, what?
When we were up here at the bench,
Step up.
yeah. I'm going to excuse y'all to the jury room.
All of this was discussed in the bench, and she's acting like they didn't discuss this whatsoever, and she's absolutely, completely clueless about what was discussed, what the expectation was from everybody. But she got the information in the bench.
My motion is a motion for mistrial, based on the actions of the prosecutor. My objection initially to the item was that it contained hearsay. The state represented at the bench that it was not hearsay. There was no hearsay contained in it. We did not address the issue of what the state already knew, which is that there was a phone number attached to it that she was going to try to elicit testimony from this witness about who that phone number belonged to. That in and of itself is speculation, but it's certainly hearsay. The document can't authenticate itself, I believe.
Not the document can't authenticate itself. Really, Adams, really?
The site for that proposition is Twiggs versus State. It's 315 Georgia Appeals 191. So this witness can't look at a document and say that it says this phone number is from Justin Cobb's Instagram or social media posting. This is who it belongs to. So that was my objection. I believe the objection was well founded. I believe the state purposely put that up there after misrepresenting as to whether or not it contained any hearsay in it. And based on that, I would move for mistrial.
It objects to a mistrial. Second, Your Honor, what Mr. Adams indicated that he did not want on here were the comments with where's the phone? There it is.
Yeah,
Okay.
the comments generally being all of the writing on the right side of the picture.
Your Honor.
Phone number is in the comments, and everything over there was asked to be not used because it would be hearsay, and that was the purpose of the objection. That it was hearsay. The information is in the comments.
And so I said to you, is any of it hearsay? Is any of it being offered for the truth? And you said no.
Your Honor.
You represented at the bench that none of this, that being the writing on the right side of the picture, which we're all squinting at because it's tiny on the piece of paper. And so I am relying upon you to actually be honest.
Judge, if you have not figured out by now, love does not know what being honest means to you, the court, or anybody. And I honestly think to herself.
With the court and opposing counsel so that we can deal appropriately with the evidentiary issue. Was any of it being offered for the truth? And you said no. And then you turned around, and after it was admitted over the overruling of the hearsay objection, based on the representation that nothing was being offered for its truth, you drew the witness's attention to the phone number and tried to have the witness testify to whose phone number it was.
We don't get there. I hear what the state's saying, and it's disingenuous because we don't get to the second step that they're talking about, what records he procured and why he did what he did, unless we go through the hearsay statement that's contained in the portion that I objected to. And the court is accurate. I was there, and I asked for everything that was on the right side, all of the verbiage to be. I said that was hearsay. The state said it was not. It clearly is, because to ask him that specific question, I mean, listen, none of us are obtuse here. It is what it is. I think that the state was disingenuous about it. The state's being very slippery in regards to their response to the court's questions.
A good way to say it. She's been very slippery to everybody, not just to the court. She's been very slippery to all questions being asked, and it makes everything seem very suspicious.
I think it's willful, and I think a mistrial is appropriate. And I'm asking
I
for one.
can't figure out what it is. If it's disingenuous, if it is that, I don't want to malign the prosecutor standing in front of me right now. So I'm not going to say the possible things that it could be, but it is.
The judge sounds very emotional as she is starting to go off on love. Let me know in the comments if you're hearing that emotion in her voice.
Baffling to me that somebody with the number of years of experience that you have, time after time after time, continues to seemingly purposefully hide the ball to the extent you possibly can for as long as you possibly can. And I really don't want to believe that it is purposeful. But honestly, after a certain number of times, you start to wonder how it could be anything but that, unless it is just that you are so unorganized that you are throwing this case together as you try it. And I am sorry to say that.
I really wish that she would not have said, I'm sorry to say that, because I don't think that Love is understanding how frustrated she is making every single person that is involved with this case. So the I'm sorry was absolutely not necessary. I know it was for proper protocol in the courtroom, but it was not necessary because this is, again, a repeated after repeated after repeated after repeated issue, and something has to give, and the apology kind of gives that softness undertone that was unnecessary.
But this case is being made much more difficult for everybody because of the haphazard way in which it is being presented. I'm going to take a recess for a few minutes. I'll have a ruling when I get back.
For people that take the law very serious, like Steele and Judge Whitaker in this moment, it being trampled on by Love is such a level of disrespect to their core as a human being, because the law is something that is absolutely super important to them. And I just don't think this will resonate with Love, and it should at this point.
All right, I'm going to deny the motion for mistrial. It's not as if the state couldn't have gotten the testimony in an appropriate way anyway. It's not like the testimony itself is that big of a deal. But I am going to, I'm going to exclude that statement and just tell the jury to disregard the statement and any testimony that had anything to do with the statement.
Of course, we get another denial for mistrial. And I have mentioned this before probably and may have gotten lost in the sauce, but I don't think she's going to call a mistrial because the state is losing. They are absolutely losing, and I think she is just ensuring and has faith that the jury will come back and say not guilty based on the case they're being presented. But we have to have the expectation that these mistrial requests are going to be denied every time at this point.
Your Honor, this is from United States versus Roberts, Roberts. It's 640F 2nd 255. It's the 9th Circuit, 1981. It's been cited many times. It's specific.
Steele is going to do nothing else. He's going to provide us with a case law, and I'm very appreciative of it.
Specifically says that continued prosecutorial misconduct may show a course of conduct establishing the intent to provoke a mistrial and bring into play double jeopardy considerations. You have not been here the whole time, and we thank you for being here. But starting with opening statement, and I know you got my motion.
I know, and I know what your argument is. Here's the thing is that, and I understand what that law says as well. Ms. Love does not appear to be trying to get a mistrial so that she can try this case over again.
I do agree with her. I don't think that Love is trying to get a mistrial. I definitely think that she is just very used to being able to stretch the limits of her decorum, and that she is just continuously trying to, because that's what she is used to. Even with being embarrassed and being stricken, she still tries because she is just 100% used to it.
I know if that were what she was doing, she wouldn't be able to try the case over again anyway. So that's just not applicable here. Now, is there continued prosecutorial misconduct merits a mistrial anyway, based on that. Yes, potentially we get to that point at some point.
Judge, we all want to know, when do we get to that point? Because at some point should be now, but when is that point in your eyes? Like, let us know so we can have make sure we take that day off and be ready to go. Because what do you mean at some point?
But there is not, from what the court's vantage point is, an indication that the state is trying to goad anybody into moving for a mistrial so that they can retry the case because they think they're losing the case. I think they think they're winning the case.
Mr. Williams, and I assume the other people on trial will agree. It is this constant hiding walls, citing law that does not stand for what it stands for, not giving over information, not answering the court, arguing with the court.
Love definitely will argue with the court. She will argue with anybody, honestly, but she absolutely will argue with the court any chance she absolutely gets. And she'll make a chance if it's not given.
And I think that it does rise to a level now, but I understand what you rule. But I think that we're well beyond it. And the reason I said promotion statement is it's literally.
Oh, I saw that. I know. I mean, I think my frustration was apparent a few minutes ago.
It was apparent, but what are you going to do with that frustration? Because you're just getting frustrated in the moment and then breezing over it like it was nothing, does nothing beneficial to us all.
But I truly am struggling with whether all of this is purposeful or this is just really poor lawyering on the part of members of the state's team.
It is poor lawyering. That sounds terrible. But what she said, it is terrible. But again, what are you going to do about it if you're not fixing the issue? Because this is not a new issue. It is a continuous issue that we are all seeing. Even the most lay person is seeing this as terrible lawyer skills. And it's not by one person on the state, unfortunately. It's multiple people, because second in line, third in line, fourth in line, they should have been said something to somebody over Love to get some stuff into shape, and that's not taking place.
Either way, it's really unfortunate. If it's something other than poor lawyering, then it is more than unfortunate.
So I was tagged about 5,000 times yesterday in the video footage saying that Love was sending messages to Sprinkle while he was on the stand, and he was being cross-examined by, I believe, Adams. So last night when I saw the messages that I was tagged in, I did respond to people and let them know that I'm like, I don't think that's what happened. It may look like that, but I don't think that's what happened, because she's on camera, he's on camera. It doesn't add up to me. So I did go ahead and take another look this morning, and the first thing that I was saying is that, they're on camera. They're on cameras in the court that the court controls and not the media. And when I first looked, that was the first thing that I saw. That camera footage is up and everybody could see it. It was up during pretty much the entire time that he was up there, especially with Adams. And it was just too direct of a camera footage for me that I was like, this is not adding up. Within that, she actually got up and went to do a sidebar and completely left the laptop open. I also stated that I'm like, Adams is like right there, like the direction she has the camera in is pointed directly in his eyesight. And someone said when you're an attorney and you're up there, you're not focused on anything else, but it is still possible that he could have been focused on it. To me, it was too risky. Let's say that. So I was like, yeah, I don't think this is what happened. It's still possible, and trust and believe if that did happen, the defense is on it. They're going to request something, get something. It'll be settled today. So I closed out the video footage that I was recording, and then I thought about it. I was like, let me go check something else. Do you see what I see? That wasn't even his laptop. Like, he got up and left and it was not his laptop. The likelihood of that being a laptop Love put up there, the likelihood of him knowing to check the messages while he's on the stand, very unlikely. So I do not think that she was sending him messages. I think that she was talking to Hilton, which is what the video footage you saw on my page yesterday shows, that she was showing something to Hilton. Her and Hilton are having conversations about whatever she is showing her, and that was that. He had someone else's laptop, and I believe he has the laptop. I don't know the lady's name or title, but not the court reporter, the other lady that sits up there by the judge. Usually she puts that laptop up there, so I'm pretty sure it was probably a laptop that she had or she uses. So I don't think that she was sending him anything. Will Love do some tricky stuff? 1000%. Always trust that she will do some tricky stuff. But did she do this that is being speculated? My verdict is no.